Het. Let's leave it at that.
Good morning. I had to check to make sure it was still morning. May it please the court and counsel. My name is Jacqueline McMicah for the petitioner, Miss Elma Het. This case is a lot more simple than the technology case I just listened to. It is a case about privilege and whether or not the respondent is entitled to overcome the privileges that are asserted by Ms. Het. Specifically, the right to financial privacy, which is not just a privilege, it's a constitutional right, and the attorney-client privilege. The basic facts are the estate of Mr. Barron has sought to sue my client for various causes of action that basically boil down to...
Is the primary complaint here the issue of the trust records?
Is the primary complaint?
Yes.
No, ma'am. There are two main issues. There's the attorney-client. The documents sought to be discovered from Mr. Mowry's firm, the law firm, which are a lot of records, that the description at least, but basically, yeah, the trust documents. The other group of documents is the financial documents, and that would include bank accounts and tax returns. So the two, we believe, are not discoverable, certainly not in the manner that the court has ordered their discovery. Primarily because there's no relevant or compelling reason to compel a discovery in this case. Initially, dealing with just the bank records, they're equally accessible to the estate. My client gave some limited testimony in a deposition that she and Mr. Barron, when he was still alive, had joint bank accounts. Presumably, the estate would have access to them, and in fact, they had copies of documents from those joint bank accounts. There's a less restrictive way of getting these documents than to invade my client's privacy. There's been no showing, except for argument of counsel, that the claimed income or gift that was vaguely referenced in the deposition of my client was sufficient to make the tax returns relevant to this cause of accident. There has been no other argument as to the alleged relevance of the tax returns of my client. This is not a case where the IRS is suing my client. And they, quite frankly, would not have the standing, unless they were the IRS, to pursue the tax returns on the stated basis, because we're not looking at tax fraud here. With regard to the attorney-client privilege, Ms. Het has not waived the privilege. A waiver, as everyone knows, has to be knowing, involuntary, and intelligent. And there have been some vague discussions about an American Express account, BB&T, Boston Bank and Trust, I believe it was called, or Branch Banking and Trust, Liberty Bank within the deposition, but there was nothing that was sufficient to indicate that my client was waiving, and she also referenced the trust that she had set up for Mr. Barron in the event that he predeceased her. Again, there's nothing in that testimony to indicate, number one, a waiver of the privilege, and number two, that the document would have any relevance, because if a trust is set up for the benefit of someone during their lifetime and they die before the settler, then that gift is not vested. So there is no standing again. There was no in-camera inspection ordered with regard to the attorney-client privileged documents, the trust documents, within Judge Bonner's order.
If the request had been made directly to Ms. Het, are you arguing that it would still be privileged?
Yes, ma'am. As the trust, you mean for the attorney?
The trust records that were the subpoena to the law firm.
I would argue that she was, yes, I would argue that those were.
And explain why you would argue that, how they would be privileged.
I'm sorry, I don't mean, you threw me off, Your Honor. I apologize. Relevant would be my argument that they're not relevant initially because the trust documents are dealing with future events, not events that have already happened. These are, and some of those trusts actually are not Ms. Het's trust. So Mr. Mowry's firm did work for Ms. Het's late husband as well with regard to his estate planning. The court didn't, Judge Bonner did not necessarily explicitly find that Ms. Het had waived, but if she had done that, she didn't delineate the scope of the waiver, which is important because it's a constitutional right as well as a privilege. And Ms. Het has the right to have that waiver strictly defined. Unless the court has any questions, I don't have a whole lot more. Just the respondent has not met its burden of showing a compelling reason and the relevance that's required for them to overcome the objections. Thank you.
Thank you.
Good afternoon. May it please the court, my name is John Bagan. I represent the respondent in this case, Michelle Barron Lundy, as PR of the estate of John Barron, who's the deceased in this case. The crux of our complaint really revolves around the misappropriation of funds from John Barron's funds to Elma Het's, the defendant in the lower case, her personal bank accounts as well as a trust. So there's three main issues here. The subpoena that we had sent to BB&T, which basically asked for bank statements, financial information for Ms. Het's personal bank accounts. We also asked for her tax returns. We also asked for her trust documents. All of this information she testified to via deposition, and she basically stated that, in her deposition, she stated that there was a transfer of money from John Barron's bank accounts to her own personal accounts as well as into her trust. She also is making a claim in the lower court that she's owed compensation, and one of her affirmative defenses is that she is owed some type of compensation from John Barron as she...
Now, when we're talking about there's two trusts, right?
As
that
far
she referenced in her deposition. There's a trust she set up for the decedent in which she's trustee, correct?
Correct. As far as I'm aware, there's one trust where she set up as, she is a trustee. She made up in the deposition testimony, she said she made it for John Barron, and it was to be funded by John Barron's funds and her own personal funds.
Okay, and so when the subpoena is made to the bank, it's requesting trust financial records, correct?
The subpoena was made for the bank, right, in Elma Het's capacity, in her personal capacity.
Individually?
Individually, yes.
Okay, but you would agree a trust is a distinct entity, correct?
It is. We would just wanted in the subpoena to capture the fact that if she's listed as a trustee on some of these bank accounts, that the subpoena would take that into account.
And were those records requested of her, directly to her, or just to the non-party, to the bank?
They were directed to the non-party,
Okay.
to the bank.
And so they weren't directed to her either by way of a request to produce or anything like that?
We had requested information relating to the trust documents, both to the Maori Law Office, which is her estate planning
I
attorney.
understand, but to her individually.
And then we requested to her individually after the fact.
But nothing, no non-party subpoena to her as a trustee of the trust?
No, no. So we believe those are the three main issues before the court. I believe the trial court gave a well-reasoned order below that basically outlines the Elsner case. And the Elsner case, and that's Elsner, Elsner versus E-Commerce Coffee Club, which basically states the law when it comes to discovery between parties, and especially with regards to financial information, and that if it's relevant to the proceedings, it's fully discoverable. Now, I know the petitioner here is making an argument that the petitioner is somehow a third party here in this case because she's a trustee, or she is potentially a trustee here, but as the lower court found, we don't believe that that's really, that bears any weight. I believe that she absolutely is a party to this case, and therefore the basic discovery rules, as in if it's reasonably calculated to lead to any admissible evidence, it's fully discoverable in the case. So we find that's the law here. I believe, without a doubt, the financial information, the tax returns, the trust documents are all not only relevant to our case, but are absolutely vital to it, because part of our case, really our case, is about showing the flow of this money. And in order to show any type of misappropriation of funds, you're going to need to show that where the funds were taken from and where they were transferred to. And we have deposition testimony that basically states that the funds were transferred from John Barron personally to Elma Hett's personal bank account or to her trust. And then based on that testimony, we had subpoenaed documents to show those documents to trace the flow of the money. And that's what we did, and that's what the trial court found was reasonable, and the trial court did allow that, and then which led to this petition. I would like to touch on some of the just the basic points made by counsel with reference to a trust itself. Trust, while it may state what could happen in future events, it does it can hold bank accounts, it can hold property, and here there's testimony showing that it did hold property, and there's evidence to show that there may hold some of John Barron's property in here. And again, this is not something that we're taking a wild guess at. This is something that was given to us via deposition testimony, which, coupled with the complaint and the counterclaim, makes these trust documents absolutely relevant to the case. And that's what the law is. The trial courts have broad discretion to rule on discovery matters, especially between parties. And that's what this is. It's a discovery matter between parties asking for financial information, and the law is clear that if it's relevant, it should be fully discoverable. And that's what the lower court found below. As to how we could get these documents by a less intrusive manner, I'm not sure how we would get financial information relating to Elma Hett by other means other than a subpoena to the bank itself. I'm sure if a request for production were sent directly to Elma Hett, it would be responded with that the documents were not in her possession, or that she would claim the constitutionally protected privacy privilege as well. So I believe a subpoena was really the only way here. It's the main way to get bank information, financial information from someone. And again, between the tax returns and the financial information, as well as the trust documents, there's an absolute showing and a basis in the pleadings to show how these would be relevant. And I don't believe the court needs to go any further than the Elsner case to discover what the law is and how to apply that law to the facts of this case, just showing that it's absolutely relevant. In terms of any attorney-client privilege issue for the trust documents, I don't believe a trust document itself, and I'll kind of back...
But that's not all was requested. It says any document indicating or describing a deposit. I mean, doesn't that go far-reaching than just a trust document?
I believe it doesn't go as far as implicating the privilege. I believe it requests the trust documents as well as...
It would encompass communications between an attorney and a client, describing, I mean, I'm just reading how it was requested.
Yeah, I understand. It's a request for a trust document as well as an accounting. Obviously, the trust document is fine, but we would need to show the money coming to and fro from the trust itself. And that was the reason for the subpoena to the Maori Law Office. It doesn't request any communications.
No, not
between-
directly, but it says any document, any document describing.
I think any document that describes money coming from one place to another
Could
place.
be a letter between a client and an attorney, correct?
And if it is a letter, then I believe that there could be some issue there, in which case it should be raised, but we're not explicitly requesting that. We're requesting the trust document as well as any document, showing the transfer of money. I believe a lot of the case law on this subject would refer to actual communications sought from a third party about some other clients or a party's trust file with their estate planning attorney.
But you're going directly to the attorney here, to the law firm, as
Right.
opposed to going to the party.
Right, and we have gone to the party subsequent.
Not to the trustee, though.
Not to her, not to her if she's deemed a different party as a trustee.
Well, is
No,
she?
I don't believe she is. I believe.
You don't think okay, I thought we talked about the trust being separate and identifiable.
Well, I believe the trust is, but I believe Elma Het created the trust for the benefit of John Barron, and that doesn't make her necessarily a third party in this case. I believe it makes her an absolute party, and if she funneled funds from John Barron's personal accounts to the trust, she's absolutely liable, not only as a trustee, but individually for converting funds. And so I believe that makes her a party to this case. Whether she's acting in her trustee for the benefit of John Barron, I still think that.
So a judgment against her individually would be able to get to the assets of a trust?
I believe it would be, yes. If it shows.
Wouldn't you have to include the trust, though, in that situation?
I don't think so, Your Honor. I believe you'd have to, you can show the flow of money coming from John Barron to Elma Het.
I understand the flow.
And her basically converting the funds in her individual capacity. So I believe you can find a judgment. Just because she moves it into a trust does not mean her as a trustee needs to be brought in as a third party.
But you'd have to bring the trust in, in which case you'd bring the trustee in to get to the assets, would you not?
I don't believe so, Your Honor. I believe you can sue her individually, and that would suffice to have any judgment against her for her actions individually, putting money into a trust illegally without my client's or without John Barron's knowledge or consent to it. So I believe, just regarding the attorney-client privileged, I don't believe a trust falls under that category. I believe the information that we requested does not implicate the privilege at all. And if there was some type of implication, obviously the trial court did not find that, but if there was, there could be potential issues of a in-camera review set up for the trial court, but I don't believe the documents we requested would implicate that. We're not asking for communications between an attorney and a client. We're asking for the showing of an accounting, basically, of the trust documents and what money came in and if any money came out and where the money did come from. And again, just the overarching issue here is whether this information is relevant in this case, and I believe it is. We're dealing with two parties to the case, Elma Het and the estate of John Barron. We're requesting documents that basically would show that what we've pled in our complaint is true or not, and that's the flow of money from John Barron's personal account to Elma Het's personal accounts without his knowledge or consent. And for those reasons, we'd ask that that this court deny the petition. And if there's any questions the court may have, I'd be happy to answer them.
Thank you.
Thank you.
Perhaps reserve just a couple minutes for a brief rebuttal.
Oh, I assumed that was assumed. So.
Thank you, Judge. Just briefly, Judge Smith identified one of the issues that I think is really interesting, because the respondent in this case is asking this court to accept this type of case from cases involving like transfers of real property and deeds that neglect to identify specific trusts. So if you have John Smith as trustee without naming the type of the trust that John Smith is the trustee of, John Smith is the owner of the property under Florida's real property law. Likewise, with regard to the UCC, if you have a promissory note that neglects to identify the name of the mortgage-backed security pool that the trustee is the trustee of, then the trustee is the owner of or given the presumption of ownership under the UCC. The words are not, the trustee is not superfluous. It has a legal effect, and it changes once someone dies. In this case, our trust is dealing with someone who is still alive, albeit she is 98 years old. And this court has, I'm sorry, not this court, the 5th District, in a case that I filed as a notice of supplemental authority. It is the Compton versus West Volusia Hospital Authority case, 727 Southern 2nd, 379. And it deals with a similar set of facts, although it's a hospital asking for a will and estate planning documents. The court in the Compton case said, we find no precedent to require the production of Compton's unpublished will in order to determine whether she was competent at the time. Similarly here, I could find no precedent to support the respondent's position, and the respondent's precedent that it cites in its brief, Ullman, actually supports our position because a potential devisee doesn't have a vested property right, and that's what Ullman talks about. And I would ask that the court consider my arguments and be persuaded by them, and quash the lower court's order or limit it upon remand. Thank you very much.
Thank you. Thank you both.
Thank you.
We are adjourned.